Hello, welcome to Legal Action. My name is David Siegel. Today we're going to be addressing viewer mail, and you can reach us at legalactiontv@aol.com, and we may choose to read your question on the air. We will protect your name, though. Nothing that we're going to talk about when we read these questions should be construed as legal advice. I want to give that disclaimer right off the top. This is for information, education, and entertainment purposes only. So please, there is no attorney-client relationship that's being attempted here, and this should not be construed as legal advice. But we do want to talk about your topics. Welcoming in Jesse Barrientos, my co-host. How are you, Jesse?
Really good, Dave. How about you?
Not too bad. This is something that we talked about.
Yep.
About doing. We do give the web address or the email address on, right. And every once in a while we do get some pretty decent questions, and this is not any different than that. We've got some wonderful questions tonight. And I guess the best way to do it is just to bandy back and forth on some of these great topics that we've gotten.
Well, let me ask some of the questions that I have for you then, that we've got for some viewers.
What do you got? Shoot.
Well, we've got, let's see, for grounds for divorce, Susan P. from Bloomingdale writes, I'm in a marriage for over 2 years now, and it doesn't seem to be working out to my ideals. We hardly talk, but we never fight. It just seems like I have a roommate. We have no children, and we currently rent. I heard that we must be living apart for 2 years to get a divorce. Is that the law in Illinois?
Well, I think what she's referring to there in general is the grounds of irreconcilable differences, which state that you have to be living separate and apart, not functioning properly for at least 2 years to satisfy those grounds. But typically what couples will do if they agree on the divorce is they'll reduce that period down to 6 months by signing a stipulation waiving that 2-year waiting period. But that's just the grounds of irreconcilable differences. So this person can proceed on other grounds where there isn't any waiting period, such as mental cruelty, physical cruelty, adultery. So it sounds like they want to go with irreconcilable differences.
Sure.
And technically there is a 2-year waiting period, but that often reduced down to 6 months, very commonly.
Well, let me ask you too, because it says living separate and apart. Okay, does living separate and apart mean? Does it mean what it says? Because a lot of times people will live in the same home because of expenses, but one person may go to another bedroom, or they may even sleep in the same bed, but they are roommates. So has that been construed to mean anything else?
The courts have determined that living separate and apart means not functioning properly as husband and wife within the same household. So yes, they can be living in the same house. They can be living as roommates. They can pass like ships in the night as long as they're not carrying on like a married couple functioning properly. If there's a breakdown, something's going wrong, that can be construed as living separate and apart. So that's a good point. And for financial reasons, a lot of people just cannot move until their house, if they own a house, is either sold or until the court makes some kind of an award. So yes, irreconcilable differences, separate apart for more than 2 years, reduce it down to 6 months, and you don't have to actually be living in a different house.
Right.
Does that answer that question?
Yeah, I think it does.
Okay, let's give you a try here. Employment discrimination.
Okay.
Greg N. from Darien writes, I work at a company with 300 employees. Although I've been at the job for longer than others, it seems I'm being passed over when it comes to advancement. Do you recommend that I talk to my boss, or do I have a claim based on some form of discrimination?
Well, discrimination covers a lot of areas. Essentially, it covers the area not only for advancement but also for termination. I could fire somebody because I don't like you, but I can't fire you because you're a specific religious background or ethnicity or gender preferences or anything like that. But with respect to Greg here, they look at a few things. They look at whether or not you're performing the essential functions of your job to your boss's expectation, whether or not you're a member of a protected class, and that's very important. Whether or not it is by race or anything else, you have to be a member of that protected class.
But just being there longer doesn't ensure that this person's going to get the promotion.
It doesn't necessarily mean that, because there are so many other variables. There has to be some kind of damage as well. But in this case, we don't know, for example, maybe the other people have more education, or maybe they have more skills. There's a lot of things, and that's why it's important for the people to know, as you've already pointed out, that this doesn't constitute legal advice. What you really need to do is to go and talk to a lawyer who's who practices in that specific area, so they can look at the specific facts of your case and advise you, because each case is different because you have different facts. But in terms of talking to your boss, it's never shouldn't hurt to talk to him. Don't go in there angry. But what he should probably do first is to go out there and find a discrimination or employment lawyer to be able to talk to and to think about. But
well, he states there's 300 employees. Should he consult the handbook, or there's some kind of guidance in writing at this corporation that he could likely find out what his deal is?
Well, when you go in and you see an employment lawyer, you want to bring that handbook if you do, and they should have a handbook in a business that's that big. But again, if they've passed you over, I mean, there are so many different reasons why or why not, and you have to explore it. Probably these days, talking to your boss means going to human resources, and unfortunately, sometimes really that's why you want to see a lawyer first. When you go in there and you start that, it may be the beginning of the end. And they start, and they might give you different shifts. They might start writing you up and doing all kinds of different things.
I noticed he didn't mention age, race, or gender,
right,
or sexual preference or ethnicity. So it sounds like he's just kind of basing this on length of service.
Right.
And he feels he's getting passed up. It's possible that these other people are surpassing him.
Right. And that's what I meant earlier about a member of a protected class. Exactly right.
Okay. Very good.
Yeah. Okay, here's one on child support. It's from Eric J. from Joliet. Writes, in my divorce decree, custody of my son was awarded to my ex-wife, and I was ordered to pay child support of $450 per month. For the past 9 months, with my ex-wife's consent, my son has been living with me. Since the child is with me, I stopped giving her child support. Although I do not want nor need child support from my ex-wife, I'm worried that my ex will someday try to enforce the old child support order against me. What is the best way to prevent this from happening?
Okay, this is a good question, and I see this a lot. What's happening here is the couple is doing something that is technically contrary to the order that's already in place at the court. So if they don't change something here, that order continues to run. And when you're talking about child support, you're talking about money accruing past due. So what I think this individual needs to do is, of course, talk to an attorney, but get into court and change that order so that there is no more child support coming out. Especially, it sounds like this is an agreed-upon situation.
Sure.
The ex-spouse or the mother or the child probably would not have a problem signing off on that agreed order if they've actually agreed to this living arrangement. Because otherwise, this guy is possibly setting himself up for a future of going back into court and having to pay child support when the child was with him. Do you concur with that?
Yeah, exactly. I mean, if she's in agreement, she'll sign off on it. You have to motion it up, which refers to getting a court date and getting it before the judge, giving the other party notice. And like you said, you want to do that right away, so it will stop. Because if you don't, maybe even the child, and I believe that the statute was changed, you can collect that for the arrearage forever. And so right. the child is now emancipated, over 18, and you've built up an arrearage now that could be thousands or even 100,000 or so. I've seen some cases where people have racked up a lot.
Some people don't want to incur the additional time and expense to go back into court, hire an attorney, and get that changed. But in reality, this is a child support that's hanging out there.
Right.
You want to rectify that as quickly as possible so that you're not damaged in the future.
Right. I mean, now the orders, right, that they have these days include a stop date, do they not?
They
Termination
do.
Date?
They do, typically. But those can be changed too, depending
right.
on emancipation events and other things like that. So I wouldn't necessarily rely on a stop date, especially if the
right.
child's now living with you. Mm-hmm. Why should you allow a child support order to be out there requiring you to pay child support?
Right, just because you trust the other person or don't think they're going to come after you.
It's too critical that gets changed.
Right.
The next question regards criminal and DUI. This comes from Anthony W. from Aurora, and he writes, I was driving with 3 friends when I was stopped by the Aurora police. One of my so-called friends, who was in the back seat of the car, stuffed his joints, I guess he's referring to marijuana, under the front passenger seat. When we were told to get out of the car, the officer saw the stuff with his flashlight. The weed was taken and I was charged. Since it was truly not my drugs, will the judge drop the charges?
Well, it's interesting. In my experience, they charge everybody because it has to do with, possession has to do with actual control over the substance. And if it's within your reach, it's within your grasp, it's within your control. So the only thing that may work for him is, and I just say may loosely because technically he's still in possession of it, but if the other person fesses up and is willing to go to court and testify if that person hasn't already been arrested.
You're talking about the person who
The
stashed
person
it
who
under
stashed
the
it
seat,
under the seat,
who didn't want
Now,
to get caught
who
with
didn't
it
want to
himself.
get caught with it. Now, the likelihood of that, it's probably not going to happen. It's probably going to deny that that it was his. But there's also some other things that you might be able to do. For example, don't know why they were stopped.
There might not have been probable
It
cause
might not have
for
been
the
probable
initial
cause,
stop.
and you can do a motion to suppress, and you have a hearing on that to determine whether or not there was probable cause, whether or not the stop was proper. And if not, then what happens is the evidence gets excluded. They call it the fruit of the poisonous tree, if it was an improper stop indeed. But, it happened in Aurora. If that's the DuPage part of Aurora, I'm not so sure. Again, it depends on the very specific facts. But
Anthony certainly needs to check his friends.
Anthony needs to check
and
his
make
friends.
some corrections there.
Right. Anthony needs to go immediately to a lawyer who practices criminal law without
Get
delay.
some detailed advice.
Get some detailed advice because they're going to want to know, it's going to want to know some more specifics.
Okay. Very good. Interesting.
Here is one on removal of minor children. It's from Lisa R. from Palatine, writes, I am divorced for 6 years and I have sole custody of my son. My ex-husband is basically an alcoholic and has not been part of my child's life for the past 18 months. I am thinking of returning to my hometown of Kenosha, Wisconsin. However, I do not want to break any laws regarding crossing the state border. I'm afraid that if I go back to court, my ex will fight me, even though he doesn't show any interest in my son. I would appreciate any suggestions.
Okay. First of all, it's a shame that the father of the child is in that condition and not showing an interest in the child. That's deplorable to a certain extent. As far as the removal goes, if it was my case, I need to see that judgment. I need to know what exactly is permitted under that judgment. It might already give her the ability to transfer across the state lines. It might not. It might be something she can do with his consent. It might something that she needs to go back into court to get an actual judge's signature on an order. So the very first thing I would do is look at that judgment, which it could be 3 pages, it could be 60 pages. We don't know. And then, of course, if it goes before the court is going to weigh in on whether or not it's in the best interest of the child,
Sure.
that the child be allowed to be removed out of the state. Talking about across the border in Kenosha, it's not that far.
Right.
You can still have visitation. The biggest thing working in this woman's favor is that the father of the child is not showing an interest and is not participating. So far be it for him to come into court now and say, I don't want them to be removed. I want to have a part in the child's life. Well, what have you been doing for the last 18 months? And how are you caring for yourself? Can the child even
Right.
be with this gentleman in his condition? So I can't give a complete answer without seeing the judgment, but she definitely, I think, has a good case for being able to remove herself and the minor child to Kenosha.
Well, what do they typically do, Dave, for example, a little bit further move? How would, in this particular case, where she said that he hasn't had really visitation in 18 months, and again, of course, it would be up to the court. But what about...
Sounds like the guy fell off the wagon.
Yeah, it just disappeared. What happens in a case where, there is kind of contact? What kind of things, if a removal is granted, what kind of things typically will the court do to try to keep the relationship with the non-custodial parent
Well,
going?
the standard is always the best interest of the child. So if the city that they want to remove to is a better environment for that child, if they have more family there, if there's more opportunity there, if the child is going to have a better life in that new location, then there's some basis to seek that removal. However, you got to weigh that against a father who may be very active in the child's life,
Sure.
who's no longer going to have that steady visitation of alternating weekends, alternating holidays, maybe a day during the week. So it's a tough thing. You go from having ordinary visitation to maybe extended time in the summer, extended time over Christmas break. It's a drastic change. It's not one that I would recommend if I represented a father to allow that.
Sure.
I would fight the removal because I would obviously feel that it's in the child's best interest that he be with me
Sure.
for as much time as possible. But in many cases, there's disinterest from the non-custodial parent to the point where removal is
No problem.
easy to obtain sometimes. So
Who would typically pay the costs of that visitation if we're talking about a further, maybe it's a plane ride away in terms of that distance?
well, I think the court's going to look to the income of the parties.
Right. Do you
But
think-
oftentimes the person who's doing the removal, they might have to bear a little bit more of that expense of transportation, but not always. It depends on the income of the parties and depends on the judge, depends on the county, so many different factors.
Sure.
Let's move it along. The next question is regarding personal injury. Jerome M. from Rolling Meadows, not too far away, writes, I have an injury case pending in Cook County for nearly 2 years now. My attorney said that the insurance company's attorneys will not talk settlement anymore until the eve of trial. I'm fearful of testifying in front of a judge and a jury, and I would take less to end it now since I need money. Do you feel that my request is reasonable, and what's the likelihood that I can get this case to settle before trial?
Well, I think that your request is kind of reasonable, but you have to look at a whole bunch of factors. There are a lot of substandard insurance companies out there, and what happens is, they litigate every single case. There are some rules in varying jurisdictions that require you to have, mandatory arbitration, which is a panel of 3 lawyers, and essentially you put your case on. It's a little bit more informal than a trial, and then there's a judgment that's awarded. And
the arbitration would have happened already since
arbitration would have happened.
Been 2 years.
Right, it depends, where they're at. It should have done, and that no doubt the insurance company rejected it. And so now you're going to court. You're going to spend extra money. If his attorney is telling him, and his attorney is really in the best situation to be able to advise him about that. I mean, that's the person that he should really, really talk to. I mean, he's had the case. He knows the specifics of the facts. He's probably went on depositions, and looked over the reports and the doctor reports and the hospital and everything else. And so that's really who we should ask. But, litigation is stressful. But you know what? You have to really, you got to buck it up a little bit. This is your case, especially if he was hurt and we don't know exactly what kind of injury it is, whether or not it's a soft tissue injury or a hard tissue injury. Hard tissue meaning, a definite fracture, something like that. Soft tissue, something in muscular or whiplash, something of that nature, because those things really do make a difference.
2 years into the case here, aren't we really just talking about the time value of money? The insurance company, if they're going to be on the hook for this, and I'm not saying they are, it could be very well a not guilty verdict, but isn't it just they're trying to hold on to the money as long as possible before they have to pay it, the time value of money benefiting the insurance company?
That is true, but you see more and more often that they're just, might as well try it because what have you got to lose? Actually, that kind of goes both ways.
It's expensive to try.
It's expensive to try, but a lot of these places are on retainer, and what that means is it doesn't matter. They've got to, they still have to do the case, the insurance defense.
The defense is on retainer.
The defense, right, exactly. That's what I'm talking about.
But the offense, you have to pay experts.
But you can't, right, you can't make somebody come in. You have to pay experts, you have to pay for their depositions, and I tell you that doctors, physicians charge a lot an hour. Plus, you have to have them come in to testify to trial, and that's going to cost you. And they charge sometimes, hey, it's a half a day. This is the rate for that, and it's a minimum of however long. Sure. So it's very expensive. If you can resolve it and settle it, that's always preferable because again, a bird in the hand is worth more. Sure. If you know you've got it and you've got it settled, might as well do it.
In this case, Jerome is stuck in the middle here. He might just have to be patient at this point.
Right, and I would definitely talk to my attorney about that and have his attorney kind of calm some of his fears. But you're here, it's at the eve of trial. Hey, you're building up because you're going to have expended those expenses if we're at the eve of trial because you have to because you don't know if they're going to resolve it or not, so you have to be prepared.
He did mention Cook County, too, which is running a little bit longer for trial dates than some of the collar counties. Is that just because of the volume of cases?
There is, yeah. There's just a huge volume of actually just about every docket you're looking at. On collecting of judgments, which is a nice thing to do. Sometimes people will do small claims or whatever. Anyway, Claire L. from Batavia writes, I won a small claims award against a former roommate for $1,200 plus costs. Although the judgment was 9 months ago, she has not paid me a dime. I know where she works, and I might know where she has a checking account. What can I do to collect since she is not voluntarily paying my money?
Well, first of all, we have a very small judgment amount that Claire has been pursuing. Is it in small claims court?
Yes.
She has the judgment already, $1,200. It's not a lot of money. It almost sounds like it's a principal thing. Claire's probably invested so much time in this case already, but there are things she can do to push this. She can bring the defendant back into court on what's known as a citation to discover assets, where that person will have to disclose where she banks, where she works, what she has in terms of assets. However, if Claire already knows where she works, I would serve a wage garnishment and probably accept 15%, depending on what she makes, as payment for her judgment, and she'll also get interest on her judgment as well as the cost of filing the wage garnishment.
She's not just going to get 15% toward her judgment. It's only per pay period.
Right.
Right, until it's paid. But she also mentioned, too, I think, that she said she knows where the other person, her former roommate, has a checking account.
Well, that's another avenue. She can do a non-wage garnishment and serve that upon the bank. And if there is money in that account, I believe up to 2.5 or 3 times the judgment amount will be frozen. She might be able to grab it all in one fell swoop if this individual has that kind of money in account. But, it all depends on what process. You might want to just see if you can work it out, too, on an individual payment plan of $100 a month over a course of a year, if possible, to avoid the additional legal expense. And
time off work. And
yeah, you don't want to spend time in the courtroom if you can work it out. But when you have someone who's stolts and just will not pay, and you have a valid judgment, you can try and collect it yourself, but I would recommend having an attorney involved who knows how to work that paperwork and knows the system and can do that. And they'll take a percentage of it, but they'll also take the load off of you.
Well, I mean, you look at that too. $1,200, it's $1,200, and it depends on the attorney.
A couple tanks of gas.
Well, these days it sure is, isn't it? Sometimes one tank of gas, depending upon the vehicle you have, right?
Right.
So it's just just because you have a judgment doesn't mean that somebody's going to pay you. That's for sure.
Yeah, and that person could also bankrupt, by the way.
And what happens then if they filed for bankruptcy?
If the defendant files a Chapter 7 and has no assets, the debt's going to be eliminated.
So even though I have a judgment, I'm not going to get anything.
Correct. It's an unenforceable judgment at that point, and Claire needs to stop trying to collect on that debt if the person files bankruptcy.
Yeah.
So let's talk about criminal DUI. Vicky T. from Lyle writes in, "My boyfriend was recently arrested for DUI. He's not sure why he was stopped by the police," common theme there, "but he cooperated by taking a field sobriety test, and he also blew. His results showed .09 for his blood alcohol level. Did he do the right thing by cooperating with the police? And is it possible that he could be found not guilty even though he blew a .09?
Well, let's go backwards, okay?
Wow.
I'll tell you, anything is possible. Okay, there could have been an issue with the breathalyzer. It could maybe wasn't tested and wasn't calibrated properly. Maybe her boyfriend had a disease or epilepsy or some other kind of issues that would have prevented him from an accurate read. Perhaps the police didn't observe him for the 20 or so minutes that they're supposed to observe him. Maybe he burped or vomited in his mouth, and before he took the test, and that all has an impact.
That'd be a sign of drinking, would it not?
Well, it would, but it also impacts the results of the test because it's a more concentration. It's a BAC, blood alcohol concentration, and so when you have that more concentrated, it's not an accurate read of what's actually happening.
His number is technically over the legal limit. Is that correct?
It is .09. There's the per se statute,
okay.
and
that's .08, correct?
It's .08. You're presumed, if that's what you blow, there's a presumption. You can rebut that presumption, but there's a presumption that you are legally intoxicated. Then there's the impairment statute, and they'll most likely have charged him under both, which even if you didn't blow .08, okay, even if you blew under that, they could still charge you, and basically saying that you're impaired.
If he were to come into your office, what would be the first thing you would do in this case?
The first thing that I would do in this case is...
I know you pretty well, so you better give me the answer I'm thinking.
Well, the first thing I would do for him in this case, the first thing we want to do is to protect his license, because his license is going to be suspended. So we're going to want to file a petition to rescind. We're going to want to do a motion for discovery. I'm going to want to ask him exactly what happened. I'm going to ask him what...
You're going to pull the police report.
What he did. Well, I'll get that from court. That's why it's the motion for discovery. And we're going to, just because somebody tells me something, what goes in the police report is different. And a lot of times, most of the time, the police officer, whatever they put in there, they have a more credibility before the court. I mean, that's kind of generally so. I mean, they're in a position of trust and all that stuff.
Okay.
If what I do, I mean, it's very hard for me. Did I do that? I would never want to tell anybody not to cooperate with the police.
Sure.
They're out there all the time putting their life on the line for us, for our safety and all that. So, I mean, I certainly don't want to say don't cooperate with the police. But from a defense perspective, I certainly, especially if I knew that I was under the influence. Well, first, the classic thing is just, you know what? don't drive. How about that? There's a
Right.
concept, right? Don't drive,
right.
okay? If you've been drinking, if you get anything to drink, don't drive. I assure you, the $150 or $200 hotel room or cab ride home is going to be more cheap than all of the frustrations you're going to have.
Oh, yes.
If you get, God forbid, you should injure somebody else or kill somebody or injure yourself. It's just not worth it. Just don't drink and drive.
So this gentleman definitely has to get in to see an attorney to go into the specific details.
To go
of
on the
this case.
specific, but but
unfortunately we can't answer anything in the specific. But
right.
just generally
For him.
speaking,
he needs to
get
go
in.
in.
And see
He
counsel.
needs to go in and see counsel, and when you get pulled over, his attorney can tell him what to do, perhaps for the next time.
Sure.
Well, Dave, we've got another question from Schomburg. It's on liability of cosign debt, and that's a lot of people cosign. So it's Stephanie G. from Schomburg writes, I co-signed last summer for my ex-boyfriend in the purchase of a Yamaha motorcycle. We broke up over Christmas, and I have not been in contact with him. One of our mutual friends stated that he wrecked the bike, and she thought that he had filed for bankruptcy. Can I be held responsible for the debt if he filed bankruptcy and listed the motorcycle?
Never co-sign debt. It just opens yourself up for liability. What she did here sounds like, new boyfriend, let's get a motorcycle, let's have some fun in the summer, I'll co-sign, I got good credit. Well, it sounds like the relationship fizzled by Christmas, was it? Mm-hmm. He may have wrecked it. He may have filed for bankruptcy. Guess what? She's on the hook. She's on the hook for that debt. When you co-sign, you are putting your name on the line to pay that debt. Whether or not somebody else files bankruptcy on it doesn't matter.
Sure.
That creditor, that lender can then look to you for payment because you guaranteed by co-signing the loan. So she really needs to find out whether or not he still has the bike. Even if it's wrecked, it could be turned in. Maybe there was insurance on it.
Mitigate some of that, sure.
They can mitigate some of the damages, and she might be on the hook for the deficiency. If he filed for bankruptcy, that's something else she really wants to find out, and she can research that through an attorney or going down to the clerk of the U.S. Bankruptcy Court, because if he filed for bankruptcy, he's out of the picture. Now she exclusively is responsible for the debt on that Yamaha, and if it's wrecked, I don't think she's going to get much use of it.
Well, let me ask you, what if, because she said, and what if he didn't list the motorcycle?
If he didn't list the motorcycle?
If he didn't list the motorcycle.
Well, most likely the debt's still going to be eliminated because whoever he hires is going to amend the documents. It's not a question of whether it was listed or
Sure.
not. It's that she co-signed with him at the time of the purchase, which sounded like maybe a great idea and a lot of fun to have a motorcycle for the summer, but it was a mistake because she's on the hook for it, unfortunately.
Well, let me ask you a related question.
Sure.
What about the Family Expense Act? And that's more in the context of divorce. If hey, you go in for medical bills or some kind of treatment, and you say, I haven't signed anything, I haven't co-signed, I haven't done anything,
Yeah.
but we're married.
Spouse
So-
could be on the hook for that if it was for a medical purpose or for a family purpose. But in this particular case, I think
Right.
they were boyfriend and girlfriend.
Right. I just want
So,
people
but
out there
you always want to be careful when you co-sign. That's the bottom line.
Sure.
Well, these are some very good questions, and we welcome your questions at legalactiontv@aol.com. And if we do choose to read your question on the air, please be advised that we are not giving legal advice. We're just basically talking about the topic, and no attorney-client relationship will be created. Jesse, thanks for joining me.
Well, thank you, Dave.
We'll see you next time on Legal Action. Take care.
Yeah.
That was so good.